Mr. Bridgigan, I'm just to start with you, and this is just a question I've had for years. And you say on page 4 of your testimony, consent is generally defined as a clear affirmative act that signifies the customer is freely given specific, informed, unambiguous agreement to process their personal data. I don't know how many times I've quickly gone through the 26 pages or 56 pages of the consent in other situations and gone to the bottom box and checked yes. I'm just curious how you or anybody would ever suggest that we're going to get this kind of understood consent from anybody in these kind of situations.
Yeah, thank you for the question. I would like to clarify a couple misunderstandings on how consent works in these privacy laws. So Texas has a very similar comprehensive privacy law as the Secure Data Act, particularly around consent and sensitive data. Texas is also the only state in the United States that has recovered over $1 billion multiple times using laws that are based on consent. There's no other state that has ever recovered more than $1 billion from a company. So consent in these scenarios is not something as simple as a click through, when you see a banner at the bottom of the screen and say accept all to privacy policies. It needs to be specific and informed. Texas courts have done a great job on explaining that each one of these adjectives has a meaning and a company needs to satisfy those specific meanings. So at a minimum, you're going to need to be able to demonstrate that the company disclosed what they were collecting the data for and how they were using that data.
So if I may, I understand the desire to achieve that type of understanding, but what are the odds of that actually happening?
Companies, well, part of that relates to the enforcement mechanisms, right? So if there's actually the risk of enforcement, companies are going to take a close look at what they are disclosing and telling consumers and how they're obtaining consent.
So let's say, if I may, the way this works, you harvest this data from millions of people. And so to suggest that these companies are going to go to millions of people and ascertain that each one has reached that level of consent seems highly unlikely. So I'm just trying to say, can you explain to me how we're going to reach that level of consent in any meaningful form?
So it would be on a going forward basis, obviously, but a company would need to, say if it was just a website that wanted to collect sensitive data, that's going to need, our position was always that it needed to be a separate disclosure, and a short disclosure, not something that is mixed into a giant privacy policy that nobody reads. It needs to be something that is very clearly informing the consumer, and so that's like you can condense that down to 2 sentences, but it does need to specifically state, like, we're collecting your geolocation data.
Again, if I may, I don't want to be too mean to my state of Oregon, but our reading comprehensive test scores are abysmal. So I wonder how anybody is going to read these kinds of things in my state of Oregon and actually understand them. But I want to set that aside because it's a terrifically important question, because the whole system now seems to be run on LLMs, and that means all kinds of data. And what you're basically saying is there's going to have to be an opt-in from an educated person who actually gets it. And I don't see that happening.
I mean, the burden is on, under the law, the burden's on the company to demonstrate that they actually obtained specific informed consent. So they're going to have to be adversely arguing that with the regulator. So that is a burden shifting. It's not as simple as a notice provision, but that ultimately will fall on, that burden to demonstrate that will be on the company.
Ms. Watts, a state-by-state regime rewards whoever has the biggest legal and compliance budget, and that's rarely a new entrant. This goes back to comments already made by previous folks. So my question is, does a privacy patchwork entrench the largest incumbents at the expense of smaller competitors? Seems to me the answer is obviously yes, but go ahead and tell me.
Yeah, we absolutely agree that a federal framework is really the way to go for small businesses. As we have discussed several times throughout this committee testimony, the compliance for small businesses and the navigation is really cumbersome and burdensome. So we do believe that a national framework will help small businesses.
Thank you. And I just want to thank the panel. Extraordinarily interesting conversation. Appreciate it very much. Yield back.